Thank you, Paul. I think you know why he's a former CBA president and general counsel of DU. Just an incredible speaker and just a lovely man. I'm very excited to introduce our final speaker before the Romaine commercial again. It's okay. I wanted it to be this way. That's how much we care about Romaine. I haven't really done a lot of bio speaking, but I am going to take a little bit of moment, if you don't mind, Justice, because Justice Corliss is just a treasure in our community. She, as many of you know, was a Colorado Supreme Court Justice for almost 21 years, is that? And trial court. Supreme Court and trial court, 21 years. The awards that she has won, just being part of our community, are astounding. The ones that of note are Citizen of the West with you and your husband. That is a really big deal, to be the Citizen of the West. And she's won all the standard sort of lawyer shenanigan awards, but the one that sticks out is the one from the Girl Scouts, right? That probably was very special. Justice Corliss is just extremely well regarded and one of the brightest justices we've had. I think that is goes without much debate. So we are excited, and she is currently, it's part of DU since 2006. You retired, you were out of work for what, 2 days before you started your new job? And I hope you speak about this, but it is IAALS, which is the Institute for the Advancement of the American Legal System. It's part of DU. And so please tell us a lot about that and how we can get involved and support your work with that organization. So our final speaker, Justice Corliss. Thank you.
We're good. So good afternoon, and like Paul, I'm honored to be here and to join the ranks of the folks who have addressed you already today. I missed Kenzo's presentation, but I consumed the PowerPoint or the materials, so hopefully that goes a little bit of the way toward educating me. I'm going to zoom up a little bit to about 30,000 feet and talk to you about the rule of law. And I'm going to do it in a way that suggests that we have work to do. And that work is not only in explaining the rule of law and what it means, but also in figuring out how to make our courts and our institutions and our delivery of legal services a lot better than they are now, because I would suggest to you that that's part of what we're facing. So the challenge, in my view, as we talk about the rule of law, is not closing ranks and defending the status quo, but is rather opening the dialogue, increasing access, and being proactive. So as I go through my remarks, which I have agreed, by the way, to shorten because I too sense a little bit of the 5 o'clock on Friday afternoon phenomenon beginning to set in, and my daughter just texted us and said the traffic is awful, so none of us are looking at a pleasant next few moments. I'm going to begin by talking about what the rule of law is, and I'm going to look to the World Justice Project's definition of the rule of law. There are 4 universal principles that the project uses. The government and individuals are accountable under the law. The laws are clear, publicized, and stable, and applied evenly, and they protect fundamental rights. The process by which laws are enacted is accessible, fair, and efficient, and justice is delivered timely by competent, ethical, and independent representatives who have adequate resources and who reflect the makeup of the communities they serve. Pretty good, huh? The rule of law is applied through 9 factors that the project also developed: constraints on government power, absence of corruption, order and security, fundamental rights, regulatory enforcement, civil justice, criminal justice, and informal justice. Those 9 factors make up a society grounded in the rule of law. Let's look for a moment at civil justice. The World Justice Project measures accessibility, affordability, freedom from corruption, discrimination, improper governmental influence, not subject to unreasonable delay, effectively enforced, and ADR, which is accessible, impartial, and effective. Does anybody want to guess where we fall on the civil justice spectrum in terms of gradations, nations around the world? Well, we'll start with our global ranking across the 9 factors. We're 18th. Regionally, we are 13 out of 24. In countries with similar income rankings, we're 18 out of 36. With civil justice, we are 28th, and criminal justice, we're 22nd. So looking across the world, comparing other countries based upon those factors that the World Justice Project articulated, and which I think we would all agree are pretty representative of what counts, we're not doing so well. So what does that mean for us in our everyday work? What does it mean for the courts? If we aren't where we should be on the rule of law index, what can we do to change that? What's the role of the courts? What is the role of lawyers? And what do we do next? The courts stand guard around the rule of law. Justice O'Connor says that commitment to the rule of law provides a basic assurance that people can know what to expect, whether what they do is popular or unpopular at the time. In fact, the rule of law is a central thesis of what all of us do every day, right? But many people would not necessarily view the rule of law the way we do it. My husband is not a lawyer, he's a rancher. And I asked him a couple of months ago what the rule of law meant to him. And he said, to me it means the rule of lawyers. And it isn't necessarily a good thing. Well, civics education. We know that people know little about the courts, and what they do know comes from odd sources. Probably now, instead of American Idol, the analogy would be Shark Tank. I bet if we walked out of here and asked any of the people whom we encountered to name 1 or 2 judges on Shark Tank, they could probably do it. But if you ask them to name justices on the Supreme Court, they might be able to name Justice Gorsuch because he's been in the news recently, and they might be able to name Justice Scalia and perhaps Chief Justice Roberts, but I bet they couldn't get much farther than that. Thomas Jefferson said, "I know no safe depository of the ultimate powers of a society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but rather to inform their discretion. This is the true corrective of abuses of constitutional power." So we know that constitutional power, at least insofar as it rests in the courts, is vested in no small degree in public trust and confidence. Here's one glimmer of hope. This is a National Center for State Courts 2017 survey, compared to the 2015 survey asking questions about whether the courts treat people with respect, listen, serve as an appropriate check on other branches. And the results suggest that we actually are doing better, which, at least from my perspective, was a little bit of a surprise. But then if you look around the world, here's an example of a violation of one of the Rule of Law Project's 9 principles, an impartial and independent judiciary. This is what's referred to as telephone justice, where the party leaders call a judge and tell him or her how to rule in a particular case. But lest we be too self-congratulatory or complacent, let's look for a moment at cash in our courtrooms, which may have some uncomfortable connection to telephone justice. In 2016, in state Supreme Court races, total spending exceeded $34.5 million across 19 states. Outside spending as a percentage of total election spending is reaching new heights or depths, depending upon how you see it. In Montana, it was 75%, in Illinois, 90%, and in Tennessee, 54%. There is at least a perception that justice is being bought and sold in the United States. Here's the pattern before the 2016 election, and this slide all by itself has a story, because some of you may have been at CJI events or otherwise and heard Bert Brandenburg speak from Justice at Stake in Washington, D.C. Justice at Stake was an organization committed to defending the impartiality of the judiciary, and among other things, they collected this data. Justice at Stake ran out of funding and closed its doors, and we don't have the updated data for 2016 on this particular axis. Judicial election spending in Supreme Courts, TV spending of $55 million, of which $20 million was outside spending. So around the country, in states unlike ours, and I'm going to talk for a minute in a minute about how lucky we are, but in states unlike ours, judges are running for office, campaigning, raising money, and then being subject to concerns about their impartiality. So what's happening on the legislative front? In Arizona, in February, the full House approved a bill that prohibits state courts from enforcing federal actions, including federal court decisions, unless those actions have been approved by Congress. The Senate has not yet taken action. In Texas, a House bill that has not yet been assigned to a committee would prohibit appellate courts from enforcing federal court orders unless given permission by the legislature. In Idaho, a bill in a House committee would prohibit state courts from enforcing federal court decisions deemed by the legislature to be unconstitutional. In Florida, the House approved a bill that would set term limits for appellate judges. The Senate hasn't taken action. And a bill was pre-filed that would allow the legislature to overturn by a 2/3 vote a Supreme Court decision that found legislative action unconstitutional. No action has been taken yet on that bill. And in Washington, a proposed constitutional amendment in a Senate committee would remove the judiciary's power to review the constitutionality of K-12 funding levels. And a bill in a House committee would allow a simple majority of the legislature to override appellate court decisions that strike down laws as violating the state constitution. There could then be a public referendum on the legislative action. So the takeaway on the state legislative front is that the authority of the courts is being questioned. The role of the courts is at issue among people who I would submit to you don't understand the importance of the courts. And remember, too, that state legislatures now have fewer and fewer lawyers in their midst. So there is a relationship between this erosion of the courts and the fact that lawyers are not part of the conversation to the same extent. I think we would agree that Marbury versus Madison is pretty clear, but I would suggest to you that that's not necessarily a universally shared viewpoint. So what do people want from the courts? What are they not getting that is causing the upheaval and the attacks on the courts and on lawyers? Here's a viewpoint about the answer to that. Adrian, can we do volume as well?
Tens of thousands of people come through our justice system each day, whether it's traffic court, housing court, or criminal court. These places can seem like factories processing cases and people like widgets. But what if these courts took a different approach? What if they focused on making each court appearance a positive one that built trust rather than eroded it? Research has documented that how people are treated is important, even more important than the outcome of their case. This idea is called procedural justice. Procedural justice has been tested in a variety of contexts, from police stops to courtrooms to prisons. In all of these settings, agencies that improve perceptions of fairness also improved public trust and voluntary compliance with the law. There are 4 primary elements of procedural justice. First, feeling like you understand your legal rights and procedures. Here's a handout about some new park rules. You can read more on our website. Second, neutrality. Feeling that the process is transparent and applied the same way regardless of age, gender, race, or other factors. Absolutely no liquids. Throw them out, folks. Third, voice, or perceiving that you had the opportunity to tell your side of the story. I understand your frustration. Please explain to me what happened and I'll try to help. And fourth, respect. Feeling treated with dignity and that your rights were respected. Good morning. Thank you in advance for helping us give each case the time and attention it needs. Mr. Smith, I apologize for the wait time this morning. Let's get started. Some would call all of this basic common sense, but it's also supported by research. When justice system professionals deliver these 4 key elements, they generate public trust. Not only that, but people are then more likely to obey the law. Perhaps counterintuitively, procedural justice works even when there's a bad outcome, like a traffic ticket or an unfavorable criminal sentence. Studies show, true, most people like to win. Outcomes matter. But what matters more than the outcome is people feeling like the process is fair. That's procedural justice. Now, most professionals are good at this most of the time, but lots can get in the way. Procedural justice isn't the solution to all of the problems our justice system faces, but it is a relatively easy and low-cost approach that can pay significant dividends and improve public trust and public safety. To learn more and for additional resources, please visit courtinnovation.org.
We can shut down the video, I think, and go back to the PowerPoint. So where are we in this climate? How does all of this come together in any kind of an action plan? First of all, our rule of law showing on a global basis is far from sterling. Our justice system costs too much, it takes too long, it's very difficult to understand or access for people without lawyers, although more and more of them are trying to get access to the courts. 2, people don't understand what the rule of law means and its importance, and I would suggest to you that the procedural justice components are a part of that, because we don't explain things. We don't assure that people get the access they need, that they can be treated fairly, that they understand what's happening to them. 3, money is pouring into judicial elections, which is compounding this perception that judges are political actors and are not genuinely impartial. 4, elected officials are openly and inappropriately criticizing judges. 5 other elected officials are exploring ways to disempower and limit the courts. Now, in Colorado, we are in perhaps a bubble because we have a judiciary whom I think all of us would regard as impartial, whom we respect, and who we believe try to do the best job they can with the resources they have. We have a Colorado state legislature who, instead of floating bills to limit the power of the courts, are instead passing judicial performance evaluation improvements, which just went through the legislature yesterday, by the way, and which reinstates judicial performance evaluation, which was to have sunsetted, and improves it in a variety of ways that we at Isles think are really important, including, by the way, assuring that self-represented litigants or pro se litigants have an opportunity to answer surveys and comment on judges. So in Colorado, we're sitting in a position that feels pretty protected and pretty wonderful. But I would suggest to you that you cannot assume it's going to stay there. You can't assume that the rule of law as we see it and as we know it is something that other people treasure. So what can you and should you be doing, in my view? First of all, civics education. I think we all have a responsibility to be out there talking to people, explaining the rule of law, the courts, what lawyers do, how important that is to a democracy and to our society. Equally importantly, from my perspective, is work to improve the system, make it more accessible, more transparent, less complex, and less expensive. We cannot be complacent. And speak out. Use analogies, be clear, be persuasive, don't be condescending or elitist. You know, I worry about that. I worry that people perceive lawyers as elitists and that we don't really understand where the law hits or where the rubber hits the road for them in many circumstances. And that there is a perception that's not entirely wrong, that we've sort of built walls around the law and around the courts so that we are the monks who have to interpret it for the populace. We cannot stay there. We cannot stay there. It is unsustainable. Up to 70% of the litigants in state courts are now self-represented. 70%. Now that's all the way from small claims courts all the way through general jurisdiction courts, but it's landlord and tenant cases and collection cases, as well as family cases in which more and more of the litigants are self-represented. The kinds of cases with which you all deal, I suspect, represent about 10% of the caseload in state courts around the country. The justice gap, as Rebecca Sandifer has coined it, the unmet legal need in the country, is even hard to get our hands around because people don't understand what their legal problems are, let alone have a sense that they can find a lawyer who can help them fix it. So there is what I would suggest to you, a crisis, but it's not the crisis of a tax so much as a crisis of our responsibility to reach out, figure out what people need from us, from lawyers and from courts, and make it happen. If we don't, this is the crisis part. If we don't, I truly believe that the practice of law, the courts as we have known them, won't be around in 20 years. They will be eroded, and the concept of the rule of law will have an entirely different meaning to the population yet to come than it does to those of us in this room. We are in the trenches. We're the people who need to commit ourselves to making it work, making the system that we treasure and that we love actually work for people who need it. And if we don't, I think they're going to figure out a different system. So, I have greatly compressed my presentation, and I'll give you two choices. One, I'll step down and bid you a good weekend, or two, I would be perfectly happy to entertain questions if anybody wants to raise them. So that's kind of a difficult position to put you in, huh? Does anybody have anything that you would like to add or ask before we... See, I knew it. The compressed presentation was the right approach. Thank you.
I think you may have a private question.
Oh, okay, yes.
Do you have a question for you? No?
No? Oh, yes. Of course.
You have to repeat the question.
As you're looking at legal systems around the world, I'm curious what other countries are doing in terms of providing access to attorneys for people who can't afford them in civil proceedings, and how does the United States compare in that aspect? And are there lessons that we can be learning from the international community about ways that we can improve our system, knowing that 70% of the people are pro se litigants at this point in
So
civil proceedings?
You're not going to like my answer. I'll tell you in advance. Access to justice globally, and I think more and more in the United States, is not about connecting a lawyer to every person who needs a lawyer. It's about changing the way legal services are delivered. So it's about, for example, in Great Britain, there's a really robust and very sophisticated online dispute resolution system that is, in fact, subsidized by the government, where people can go online and have access to an arbitrator or a judge to resolve their disputes, and then whatever they decide in that context can be filed in the courts. Similarly, in Great Britain and Australia, as I'm sure you know, the regulation of lawyers is changing significantly, so that there are fewer boundaries drawn around what the unauthorized practice of law is, and there's more opportunity to sort of reshape that. In Washington State and Utah and Idaho, the limited license legal technician programs are taking root. The use of unbundled services is something that we at ISLES support and are trying to encourage lawyers to offer, so that clients can have a la carte services on an hourly rate, and they need not hire the lawyer for the whole matter, particularly in litigation. So I think that what's happening around the world is that legal services and the delivery of legal services is no longer viewed as something that necessarily needs to be provided by a lawyer. Some examples of that in the United States: the Legal Services Corp is working with Microsoft to develop a portal that people will have access to, which will allow them to diagnose their legal problem and then get referrals to various sources. There will be components of it that will be things like TurboTax that will help them fill out forms if necessary. I saw a presentation last week at Stanford of something called VisaBot, which is a chat bot for people to help them figure out their immigration issues. And it's interactive. It asks a whole series of questions, and then it helps them determine what the right avenues are for them to achieve the goal that they want to achieve. There's another one that's called Do Not Pay, which is how to get out of a traffic ticket, which was developed by an undergraduate, I'll have you know. But those are the kinds of things that are starting to happen, and they're happening in the United States as well. The Colorado Supreme Court just debuted, or is about to debut, the Colorado Supreme Court Law Library portal, which is an effort to open up access to legal information for people all around the state, be they lawyers or not lawyers. So I would answer your question by saying that I don't think any of those countries have necessarily married up a lawyer with every with every person who has a civil legal need, but they are doing a better job of figuring out how to provide physician's assistants or nurse practitioners or whatever it may be in order to address those needs in a graduated way, and saving the lawyers to practice at the top of their license as the surgeons, if you will. Anything else, anybody? Okay, yes, one more.
I just was curious if there's something very concrete that you would recommend here in Colorado. I know we have a social justice commission and there's a lot of things effort underway, but should we go like what are we going to do?
So re-examine triple LT for me, because Colorado took a look at it and decided that it was probably not the right thing for us. Since that point in time, the study on the state of Washington's use of limited license legal technicians has come out, which suggests that they are meeting a need and that they can be regulated appropriately. So take a look at that. And sort of from my perspective, what we try to do at ISLES is walk like a client. And I actually have a slide that has the whole little Egyptian thing going on it. But the concept is to think about these problems from the user's perspective and to think about what you would need if you were in litigation or trying to address a legal problem of some sort, rather than thinking about it from the lawyer's perspective. So that's sort of the granular answer, and the more paradigm shift answer to your question. Go online to our website. It's isles.du.edu. We have a variety of projects ongoing, and we always welcome feedback and input. We always welcome opportunities to speak to folks. There are ISLES representatives here today. Donna Playton, who handles our family justice program, is right there. And Carolyn Tyler, who's our communications expert, is in the back of the room. So we stand ready to help in any way that we can. We're very dedicated to this work. Thank you again. Drive safely.
Okay, so I'm going to call an audible on the program. There is beer and wine and food in the lobby, and I know this was a time for some of our nonprofits to present, but I kind of want to combine it. So I encourage you all. I think we started off by saying do something, and we have ISLES here, who's just a tremendous organization. Professor Playton, who is my professor at the University of Wyoming, is just tremendous. And so please speak to some of these folks. Michaela Romaine is going to stick around. I cannot stress enough that the current crisis and need is in immigration work. I'd also like to give just a plug to some of the just incredible faculty we had here. Kenzo is one of the best partners at DGS. He does nothing but very complicated commercial litigation. He's one of the best trial attorneys in the state. Bill Berger is one of the very best management side employment lawyers in the state. If any of you have work in that, he is fantastic. Sarah Parody at Lowry Parody is one of our rising stars and one of the very best plaintiffs employment lawyers also in the state. So if any of you have work, these are folks who came here, volunteered their time to give you their information. So with that, thank you so much for your just great questions, great attentiveness, and I wish you the best and drive safely.